how business should reassess boilerplate contract language in a post-COVID world. Topic of my conversation today with two attorneys from the law firm of Nixon Peabody. I'm joined by Amy O'Keefe. She is a partner in the private equity and investment funds group. Hello, Amy.
Hi, Bob. So happy to be here with you today.
Thank you. And Teray Howell. He is an associate and litigator with Nixon Peabody. Hello, Teray.
Hello, Bob. It's a pleasure to be here.
So let me start with you, Amy. Just give me a general question of what boilerplates are most relevant here to this whole discussion as they impact supplier and customer relationships in the supply chain.
Yeah, absolutely, Bob. So, when we're talking about boilerplate, what we're really talking about is, what some people think of it's the fine print at the very end of a contract, right? So you've got your business terms, and then often at the very end, there'll be a section that's labeled miscellaneous or other provisions. And that's the boilerplate that we're really talking about and focusing on today. These provisions are often standardized across all contracts. And a lot of times people will pay a ton of attention to the commercial terms of the agreement and not so much to the boilerplate. But, as Teray and I are going to talk with you about today, Bob, they're really important. Those provisions are substantively operative in the eyes of the law, and they have meaning, and they can really be outcome determinative in certain cases.
Yeah. You
So
copy and paste this language into contracts, and you have to make sure that you know what you're doing, right?
That's right. Do so at your own peril, for sure.
Yeah. One of the most used, I assume, boilerplate language in these contracts is that of force majeure. That's getting a real workout these days, isn't it, Amy?
Yeah, indeed. It certainly is. So the force majeure clause, I think, is very important, particularly in supply contracts and commercial contracts like the ones that we're considering here. So those force majeure clauses, are generally, aimed at under what circumstances can a party to a contract get out of its obligations under that contract. And it used to be pretty simple, right? It used to be that it was just, if there were unforeseen circumstances that no one could control, you were allowed to get out of performing under that contract. So you think of things like an earthquake or a hurricane or a labor strike. Those were all sort of standard force majeure events. And I think that people didn't give it very much thought until COVID came. And there have been supply chain disruptions and all sorts of issues around fulfilling contracts. So it's become really important now to take a fresh look at that force majeure language and make sure that the parties really understand what their obligations are under what circumstances. So when should performance be excused? And is COVID foreseeable at this time? We've been living with it for 14 months. So perhaps it is a foreseeable event, but what about the next pandemic? And how are you going to deal with that? So these are the questions that people are asking themselves when they're drafting.
Yeah, there's a whole question of whether COVID was a black swan or a white swan, whether it was something that was a complete surprise or something that we should have all been prepared for all along. Teray, what about the potential pitfalls of relying on boilerplates in contracts? What are some of those?
Yeah, well, some of the pitfalls are the fact that parties might not fully understand their obligations under the contract. So, for example, if you're going to implement and try to take advantage of the force majeure provision, you want to analyze the provisions to ensure that you've complied with all requirements. For example, some may have notice requirements where you're required to provide notice to the unimpacted party through a certain means and within a certain time period. If you do not fulfill that notice requirement, for example, you might not be able to take advantage of the force majeure provision. Also, for example, parties should consider whether other aspects of the agreement actually define what effective notice is. Oftentimes, the notice provision is actually completely separate, and it may require you, for example, to send it via DHL, facsimile, which is like who uses fax nowadays. It may prohibit notice via email, but I think a lot of parties sort of operate on autopilot and will just automatically assume that, okay, I sent a quick email to let you know that we're having issues, and may think they can rely on the force majeure provisions, but that actually may become problematic.
Mhm.
Another thing a pitfall that may arise is if the force majeure provision actually has a priority obligation. So there might be some provisions out there that requires you to the best that you can, prioritize this particular contract in order to try to minimize the impact of the force majeure event. Some instances, for example, if the force majeure event has caused a company to be adversely impacted across a number of contracts, but multiple contracts have a priority provision, then you can be in a bind. So parties want to pay attention to the terms once a force majeure event happens and actually come up with a strategy as to how to use it, because it's there for use, and you want to make sure you're complying with all the obligations in considering them as you move forward.
You've already hinted at some of the answers to this following question, but that is, what are some examples of where boilerplate language has led to unintended consequences over the past year, say?
Yeah, so that's a great question. So one example has to do with a New York federal court opinion in late 2020 related to the pandemic. And in this case, the federal court actually excused one party's performance from the contract because it found that the COVID-19 pandemic constituted a natural disaster within the meaning of the contract. This was a case that had to do with the sale of artwork. So essentially, an auction house agreed to sell artwork in May of 2020 in New York City. And the contract was entered into in 2019, well before anyone was even aware of the fact that there was a pandemic coming. After the government restrictions came down through the governor of the state of New York, one party that was supposed to actually host the actual auction canceled the contract and invoked the force majeure provision. And the court upheld it and essentially dismissed a lawsuit that was initiated by the other side for a breach of contract. The court determined that it cannot be seriously disputed that COVID-19 constitutes a natural disaster, and it relied on a law dictionary definition of the word natural in order to reach that conclusion. The consequence was that not only was the auction house excused from performance, but it was excused from fulfilling any obligations that it had with respect to breach. For example, this contract had a $5 million guarantee, where if the artwork wasn't auctioned for a certain amount, you would get this $5 million from the auction house. But since the performance was excused under the contract, then that obligation went away. So that is something that parties obviously want to think about as they're defining the breadth and scope of force majeure provisions going forward, because not only the sale didn't happen in this case, but also you didn't get a chance to take advantage of what we call like the liquidated damages provision.
Yeah, wow. Amy, how does such language need to be adjusted or revised in the current environment and going forward?
Yeah, so Bob, we would absolutely recommend that the parties to these supply chain contracts, dust off their boilerplate, give it a fresh look, because the world that we're living in today is not the same world that we were living in 18 months ago. So you really do have to look at these provisions, particularly the force majeure clause, and make sure that you are going to get the benefit of the contract that you're signing up for. So when I'm thinking about negotiating these force majeure clauses, some of the things that I'm thinking about are, what should constitute a force majeure event? So if I'm representing a supplier, we want a big, broad definition of what constitutes a force majeure. So all of the normal stuff, the earthquakes and the hurricanes and the labor strikes, but also this pandemic, future pandemics, any impacts that come from governmental regulations that are handed down to deal with pandemics. So it's gotten broader from that perspective when I'm on the supplier side. When I'm on the customer, the buyer side, you want it to be as narrow as possible. So it's trying to chip away at some of the things that the supplier may be pushing for to make sure that you understand the universe of what might trigger a force majeure event and that you're comfortable taking those risks.
Wow. Yeah. Yeah.
And sorry, Bob, just
no, go ahead. Go ahead, please.
One other thing that I often think about when I'm negotiating these contracts is, okay, so you get to a force majeure event, but then what does that mean? I find a lot of times I'll read a boilerplate provision that will very nicely define what triggers a force majeure event, but then it doesn't go to the next step and tell you, okay, does that mean that the supplier can get out of performing entirely? Or do they just have a temporary suspension of their obligation, but they ultimately do have to perform? Or do they have to perform to a certain level that they can perform to, but then anything in excess of that is excused? So we've got to make sure that we're telling the, not just the joke, but also the punchline. You've got to finish the thought.
Wow. Teray, have you experienced that too, where that was just overlooked, those fine details as to what the implications of a force majeure clause actually are?
Well, I haven't experienced it personally, but I've seen cases where parties are not really paying attention to the impact, and that goes to what Amy is saying. You have to understand what your obligations are and make sure you follow through.
Mm-hmm. Wind and currents causing a ship to go off course and block the Suez Canal. That sounds like a force majeure to me, but who knows? I don't know if they're managing to invoke that properly or not.
Cybersecurity. Sorry,
yeah.
I was thinking of the gas pipeline issue that
right. Yeah, that of course, anything that has, yeah, for sure. So how should the parties to a contract approach the whole issue of boilerplate language in the first place? I mean, should they be rethinking the very notion of what is of boilerplate, of just dropping in language from other contracts? Should everything be approached in a completely fresh way? I mean, Amy, going forward, how should the parties be looking at this whole issue?
Yeah, that is such a good question, Bob. I think that's really the heart of the matter, isn't it?
Mm-hmm.
So, from a practical perspective, I don't think that a lot of commercial parties have the bandwidth or the legal resources to give a fresh look to boilerplate with every single contract that they sign. But we would really encourage people to dust off that boilerplate, on an annual basis and re-examine it with an attorney, ideally, because business realities change, things evolve, but so does case law. I mean, Teray litigates this stuff all the time, and the landscape really does change, and it's ever moving. So, if you can't have a lawyer look at every single contract you're executing, certainly have an attorney help you to think through, evolutions or changes to boilerplate that may be needed to deal with new business and legal realities on an annual basis.
And for those of us non-lawyers, we should not allow our eyes to glaze over legal language like we have in the past, because it's also very important. Thanks so much, Amy O'Keefe. Thank you to Ray Howell for your insights into what's turning out to be an extremely important aspect of contractual negotiations between shippers and between suppliers and buyers these days in the supply chain. I want to thank both of you for being with me. Really appreciate it.
Thanks for having us, Bob. This was fun.